endelea.
Concluded until the 27th of February 2020. There's a bit of interruptions from some quarter. I took over hearing of this case on the 5th of July 2021, and in the course of the trial, a significant amount of time was taken in the determination of interlocutory applications. It is noteworthy that in the course of the trial, I had and determined a record 16 interlocutory applications. Another reason which contributed to delay in the conclusion of this case was a transfer of the trial judge in September of 2022 after hearing a total of 25 witnesses. Hearing of the case thereafter stalled and resumed about a year later on the 17th of July 2023 after the Honorable Chief Justice directed that I should continue trying the case to its conclusion. The counsels in this case are as follows. I think it is important to mention the legal team that represented the parties during the trial. When the trial started, the lead prosecution counsel was Landed Counsel Ms. Catherine Mwaniki, assisted by Landed Counsel Ms. Gekoi Geshohi and Landed Counsel Ms. Betsy Gekonyo. But in the course of the trial, Ms. Gekoi Geshohi took over the role of lead prosecution counsel, assisted by Landed Counsel Ms. Betsy Gekonyo and at times Mr. Alan Mulama. On the defense side, the first accused was represented by Landed Counsel Mr. Kioko Kilukumi, Senior Counsel, assisted by Landed Counsel Mr. Rogers Sagana and Landed Counsel Ms. Mwanzia. The second accused was represented by Professor Tom Ojeda, Senior Counsel, assisted by Counsel Mr. Uganda Meso and Landed Counsel Ms. Catherine Msando. The third accused was represented by Landed Counsel Mr. Elisha Ogoya and Landed Counsel Mr. Jack Oronga. But in the course of the trial, Mr. Ogoya dropped from the case, leaving Mr. Oronga to continue representation of the third accused. Lastly, the victim's family was represented by Landed Counsel Mr. Daniel Joroge and Landed Counsel Mr. Hezekiel Awor. In support of his case, the prosecution called 42 witnesses and produced 81 exhibits. The prosecution case is that the first accused was at the material time the governor of Migori County, while the second accused was his personal assistant. The third accused was a clerical officer employed by the county government of Migori. The prosecution presented evidence that proved that the first accused was in an intimate sexual relationship with Sharon, who was then a second year student pursuing a diploma in medical health at Rogo University. Sharon's mother, Ms. Melida Auma Rangili, who testified as PW30, testified that in the year 2017, she was living together with Sharon and her 3 children in her home. In February or March of 2017, she recalled that Sharon was pregnant and she realized that Sharon was pregnant and seemed unhappy. Upon inquiry, Sharon confided in her that the first accused was responsible for her pregnancy and that he had become evasive as he was not picking her calls and had also withdrawn financial support. PW30 further recalled that between March and May of 2017, Sharon told her that she had met the first accused in Nairobi, and he had told her that he was not ready for the pregnancy and she should terminate it. He gave her 30,000 to terminate the pregnancy and directed her to deal with the second accused for matters related to the pregnancy. Upon advice from PW30, that is her mother, Sharon decided to keep the pregnancy. According to the evidence of PW28, Mr. Lawrence Obonyo Owor, on 20th of July 2018, he was in one of the hotels in Homa Bay town when Sharon approached him seeking financial assistance. He promised to give her what he could on the following day. On the following day, they met in the same hotel, and as they were having tea, Sharon requested him to recommend a journalist who could assist by publishing her plight in the in the mainstream media, to force the first accused to give her attention that she felt she deserved. On the 25th of July, PW28, that is Lawrence Owor, organized a meeting between Sharon and a journalist at Tourist Hotel in Homa Bay. The journalist testified as the journalist was PW9 and testified as a protected witness under the pseudonym of XYZ. According to PW9, Sharon narrated to him her personal details and confided that she was in an intimate relationship with the first accused who had abandoned her after impregnating her, and that at the time she was 7 months pregnant and she was facing financial hardships, she wanted PW9's assistance by having her story published in the newspapers to force the first accused to reach out to her. PW9, that is SYZ, further recalled that he took photographs of the deceased and screenshots of WhatsApp communications between her and the first accused. Sharon also played 2 audio recordings of conversations between her and the first accused, and in the first recording, the first accused was pleading with Sharon to stop posting her images on social media, especially Facebook, particularly photos of hotels they had frequented, while in the second recording, he was beseeching her to procure an abortion, stating that time was actually running out. After a few days, PW9 communicated to the first accused through a mutual friend, as he wanted to hear his side of the story before acceding to Sharon's request. When he reached out to the first accused through that mutual friend, the first accused called him, and in the course of their conversation, he invited him to visit his home at Rapogi together with PW28. They both accepted the first accused's invitation and went to his home the same evening. After sharing a meal, they had a meeting in which the issue of Sharon was discussed. And during that meeting, the first accused admitted knowledge of Sharon's pregnancy, but complained that her expectations of him, as narrated by PW1, PW9 were unrealistic, as she was demanding a good car, a house in Nairobi, and a good job. And in communicating these demands, PW9 indicated that he had Sharon's instructions to publish her illicit affair with the first accused in the media if her demands were not complied with. In response, the first accused requested PW28 to contain the situation by talking to Sharon and identifying her needs. He also advised that any future communication relating to Sharon's pregnancy should be channeled through the second accused, his personal assistant. According to PW9, at the end of the visit, as the first accused was bidding them goodbye, he instructed him not to tell anyone about Sharon's pregnancy. The second accused also called PW9 a few days later and notified him that Sharon's matter would be resolved amicably. About a week after the Rapogi meeting, PW28 met the first accused alone at Serena Hotel and later at Heron Hotel, also in Nairobi. PW28 in that meeting shared to the first accused information received from Sharon that Sharon required between 20 to 25 million to buy a house in Nairobi or Kisumu, a good vehicle, and money for her upkeep. The first accused made a counter proposal offering to buy her a plot at Homa Bay and constructing for her a 3-bedroomed house. PW28, that is Mula, was asked to share this counter proposal with Sharon and returned feedback to the first accused. And as instructed, PW28, Lawrence, discussed the matter with Sharon, who accepted the first accused's counter proposal. And when he communicated to the first accused Sharon's acceptance of her proposal, according to PW28, the first accused promised to avail the money needed for the purchase of the plot and the construction of the house by end of August 2018. On the 23rd of August 2018, PW1 recalled having received a call from Sharon informing him that the first accused, through the second accused, had requested to meet them in Nairobi urgently. PW9 then called the second accused for confirmation of that information, and the second accused confirmed that that was true and added that the first accused would meet their transportation costs. And on the night of 23rd and 24th of August 2018, at around 3 a.m., PW9 received 22,000 through his M-Pesa from a lady identified as Veronica Wageshi. This was PW4. PW4 testified that she was on duty on 23rd of August 2018 as a receptionist at SIGNET Hotel, Nairobi, when a man she was not able to identify requested her to send through her Safaricom line 22,210 to PW9's mobile number, allegedly because he did not have a Safaricom line. The second accused, in his defense, admitted having sent the above money to PW9 through PW4 to facilitate Sharon's and PW9's flight to Nairobi on the same day. There is evidence from PW5 and PW9 that Sharon and PW9 took an early morning flight from Kisumu to Nairobi on the 24th August 2018. On arrival, they met with the second accused at Capital Center, who later catered for their accommodation as he allegedly made efforts to schedule a meeting for them with the first accused. Unknown to Sharon at PW9, the second accused had also facilitated the travel of Lawrence Muller to Nairobi on the same day, ostensibly for the same purpose of having a meeting with the first accused. However, the promised meeting failed to take place, and disappointed the trial, that is PW9, Lawrence and Sharon, returned to Homa Bay in the evening of the following day. According to the evidence of PW9 and PW28, that is Stu Mura, between 27th and 29th of August, the second accused called them separately using an Airtel line number 0739473321, informing them that in future they should communicate with him using that line. He, however, gave them different reasons for that instruction. According to the evidence of PW9, the second accused claimed that he had lost his Safaricom line, and that is why he had asked them to communicate through the Airtel line. Well, according to Lawrence, he claimed that the second accused had claimed that his Safaricom line had been blocked by children and he had not had time to unblock it. Further, through the evidence of Noah Omondi Odoyo, who testified as PW26, an Airtel shop attendant in Migori, the prosecution alleged that the above Airtel line, that is the line that the second accused acquired and instructed PW9 and Muller to be using in any communication with him, that line had been registered using a national identity card, which was issued in the name of Vincent Abonyo. Vincent Abonyo, in his testimony, recalled that he had lost his identity card while at Kenya Commercial Bank in Migori, and that he had already obtained his replacement. He denied having registered the Airtel line used by the second accused to communicate to Sharon, PW9 and PW28. On the PW28 record that in late August 2018, the second accused called him using the Airtel line, and they subsequently had a meeting outside Tausi Hotel at Rodi, during which the second accused asked PW28 to keep off Sharon's affairs as he would henceforth deal with her issues. On being cross-examined by Mr. Awor for the victim's family, Lawrence recalled having written a statement confirming that in that meeting, The second accused had asked him how they could get access to PW9's and Sharon's mobile phones since they contained evidence that could take the governor to the media. According to the evidence of XYZ, that is PW9, Sharon called him on the 3rd of September 2018 at about 5 p.m., informing him that the second accused had conveyed a request from the first accused that they should meet at Rodikopani in Homa Bay County. They acceded to second accused's request, and on arrival at Rodikopane, Sharon contacted the second accused, who redirected them to Rongo town. They proceeded to Rongo and went to Grasa Hotel, where they waited for the second accused. And when he eventually joined them in the hotel, the second accused informed them that the place was too open for him to communicate the message he had from the first accused. He requested that they should move to another venue. XYZ further testified that as they exited the hotel, they found a dark vehicle parked outside the hotel entrance, which the second accused allegedly asked them to board, claiming that it belonged to him. On boarding this vehicle, he noted that it already had two occupants, a driver and a person seated on the passenger seat. PW9 sat behind the driver. Sharon sat in the middle, while the second accused sat behind the front passenger seat. The vehicle then left the hotel, and as it was being driven towards Rongo town, and was driven towards Rongo town, but subsequently changed direction towards Homa Bay town. Along the way, near a petrol station, PW9 claims to have seen two people standing by the roadside. It was now evening around 7:30 p.m. He recalled that the second accused ordered the driver to slow down, and when he did, the second accused exited the vehicle. The two unknown men who were with them in the vehicle he had seen standing by the roadside entered the vehicle and sat at the rear seat, sandwiching Sharon and PW9. He was able to see the two men seated with them at the rear seat, but he was unable to see the driver and the man seated on the front passenger seat, who appeared to be receiving instructions from somewhere, as he was constantly on the phone. As the vehicle sped towards Homa Bay, one of the men ordered them to switch off their mobile phones and surrender them together with their other valuables, which they did. The same man, who he was not able to identify, asked him whether he had a tape recorder, and the other man started searching his pockets. The man seated next to Sharon, according to PW9, asked Sharon about her relationship with him and how she had met the governor, which Sharon explained. The man seated next to PW9 also asked him how he had met Sharon and why he was doing a story about the governor. And as Sharon got distressed and started crying, one of the men told her to stop crying as they were taking her to the governor. According to the evidence of PW9, as the conversation continued, and at this time the vehicle was still in motion, the man seated next to him became violent and started strangling him, asking him why he was following the story about the governor. This man then lowered his seat to an inclined position, and taking advantage of this development, PW1 wiggled his way from his grasp, opened the doorknob of this vehicle, and jumped out as the vehicle was still on transit. He fell on the tarmac and rolled off the road. And he also noted that the vehicle had stopped a distance away, and two people started running towards him. He started running away from them in the direction of lights he saw from a distance, which led him to a home in which he took refuge. According to the prosecution case, this home belonged to Mr. Kennedy Kasera, who testified as PW27. In his evidence, PW27, Mr. Kennedy Kasera, narrated how on 3rd September 2018 at around 8 p.m., a man stormed into his house in a panic and went straight to hide under the bed in his bedroom. He was surprised because he did not know this person before. Upon inquiry, this man explained how he had been abducted together with Sharon and how he had escaped. He noted that this person, obviously referring to PW9, had fresh injuries on his hands and knees which were bleeding. PW27 then took PW9 to Cadell Police Post, where they reported the matter to PC Willie Okoti. PC Willie Okoti testified as PW number 6. In his testimony, Mr. Okoti recalled having noted PW9's injuries on his palms and knees, and that his trouser was torn around the knees. He also noted that he was visibly shaken as he was trembling when making his report. He then booked PW9's report and also disseminated it to OCS Kedube Police Station. He disseminated it to the OCS, that is Officer Commanding Kedube Police Station, who, accompanied by other police officers, who included PC Towai, who testified as PW11, and PC Roymen Laisalel, who testified as PW25. They went to Cadell Police Post, picked PW9, and escorted him to Kedube Sub-County Hospital for treatment. At the hospital, he was treated by a clinical officer, Mr. Haran Diero Ajwang, who testified as PW10. In his evidence, the clinical officer recalled having noted fresh injuries on PW9's hands and knee joints, which were actually bleeding. In his opinion, the injuries were soft tissue injuries since there were no fractures. He took treatment notes on a notebook, on the basis of which he later filled a P3 form, which he produced in evidence as exhibit number 16. In the course of his long and detailed testimony, which the court recorded for several days, PW9 identified the vehicle in which he was allegedly abducted together with Sharon. It was motor vehicle registration number KCL481K, a Toyota Fielder, grey in color, which, according to records maintained at the National Transport and Safety Authority, NTSA, was owned by Miss Olivia Olo, who was the third accused's wife. The vehicle was being operated as a taxi, and his driver was a Mr. Jackson Otieno Gombe, who testified as PW38. According to PW38, Mr. Gombe, on the 3rd of September 2018, he received instructions from Olivia, who was the owner of this vehicle, who instructed him to take the vehicle for valuation at Invesco Insurance in Migori. PW38 recalled that accused number 3 directed him to the insurance company offices to get the valuer's telephone number. And after getting in touch with the valuer, he proceeded to Olivia's house to get a copy of the vehicle's logbook. On arrival in Olivia's home, he claims to have found the second, the third, and another person identified as Dicky seated together outside the house. He also recalled that as he was leaving, this Olivia allegedly warned him not to tell anyone about what he had witnessed or what he had seen in that home. In addition, PW38 testified that later the same day, between 4 and 5 p.m., a police officer known as Elvis, who also testified in support of the second accused person's case, who was also one of the bodyguards attached to the first accused, called PW38 and allegedly instructed him to pick the second accused at Oriri at around 6 p.m. and that the second accused would then direct him where to go. He claimed that he knew Elvis as he used to see him with the first and third accused, and he sometimes gave him work, such as picking up customers and relaying information to third accused or his wife. PW38 recalled that he complied with those instructions and proceeded to Oriri, where he found the second accused in the company of 2 unknown men. The 3 of them boarded the vehicle and he drove them to Gracia Hotel, following instructions from the second accused. On arrival at the hotel, the second accused alighted. The second accused was the only person who went to the hotel, while the other two men were left standing behind the vehicle. And after about 10 to 20 minutes, the second accused emerged from the hotel, accompanied by a lady who appeared pregnant and another person, or another man. According to his further evidence, all the unidentified men who had been in the company of the second accused boarded the vehicle, but the second accused did not. One of these men instructed him to drive to a nearby petrol station and park by the roadside, which he did. Shortly thereafter, the second accused joined them, appearing to have crossed over on foot from Gracia Hotel. And after the second accused engaged in a discussion with with the unidentified men, these men boarded the vehicle, one on each side of the rear. Two of them sat on each side of the rear seat of the vehicle, meaning that Sharon and PW9 was sandwiched between these two men, while the other man sat at the front passenger seat. According to PW38, Mr. Gombe, when driving towards Kisumu as directed by one of these unidentified men, he had them questioning Sharon and PW9 about their relationship with the governor, referring to the first accused. He decided not to follow up with the conversation since it did not concern him, and he increased the volume of music in the vehicle. After driving for some time, he claims to have sensed a gush of wind blow into the vehicle, as if the rear door or window had been opened. He recalled that he was at the time driving at a speed of about 60 kilometers per hour. He slowed down, and on asking what was happening, one of the unknown men seated behind him dismissed him, saying, "Wachana na hii fala," and he proceeded with his journey. As he continued driving, he was being directed by one of the unidentified men on the roads to follow. And eventually he was led to a rough road in a forested area with no homes nearby. At some point, he was instructed to stop, switch off the vehicle's engine as well as its lights, and wait. When this is the time that he realized that one man who was previously in the vehicle was no longer there. As when the occupants of this vehicle alighted, he noted that one of them was not there. as only a lady and 3 men alighted. He complied with instructions to wait in the vehicle, and after about 10 to 20 minutes, the 3 men returned, but without the lady. Upon inquiry, he was informed that the lady had been left at their home. He was then directed to drive to Oriri, where the unknown men alighted between 9 and 10 p.m. He thereafter drove to his home in Migori. The prosecution also tendered evidence that in the morning of 4th September 20, a clinical officer at Migori County Referral Hospital, Mr. Justice Windy, received a call from a man who identified himself as Caspal Obiero. Justice knew Caspal before because of his association with the then governor of Migori County. Justice testified as PW22, and he identified Caspal in court as the third accused. He recalled that after receiving this call from the third accused went to see him in the hospital, accompanied by the second accused. The third accused then informed him that they required his assistance on an issue related to treatment. The second accused took over the conversation and explained that he had been attacked by unknown people the previous night at Kisii, and he had been robbed of money belonging to the first accused. He therefore needed a medical request form issued by a hospital in Kisii, confirming that he had sustained injuries on the previous night, as he needed to protect his job. PW22 recalled that upon receiving this request, he contacted his colleague at Kisii Teaching and Referral Hospital. His friend was Mr. Cliff Momanyi, who testified as PW20. PW20 recalled that on this date, that is the 4th of September 2018, at around 10:30 a.m., he was at his place of work when he received a call from his friend, Mr. Mwindi, who requested him to assist his friend, who he identified as Mr. Michael Oyamo, by issuing him with a medical request form prescribing multiple medical investigations, including chest x-rays, MRI, and CT scans. And although he did not know or examine the said Michael Oyamo, he fabricated treatment notes and a computer-generated outpatient card purportedly issued at KTRH, that is the Kisii Teaching and Referral Hospital, as a favor to his friend, Mr. Justice. These documents were produced in evidence as Exhibits 31, A and B. He recalled that on the same day at around midday, that is PW 22. He delivered the medical reports to third accused on the instructions of the second accused. On the same day, that is 4th September, PW 23, a police officer at Oriri Police Station, that is Philomen Fidel, is a Sipai. He was at the police station on duty when the second accused went to the police station and reported a case of abduction. According to PW 23, the second accused alleged that on the evening of 3rd September, he was at Gracia Hotel with a lady by the name of Sharon and another man, and that on leaving the hotel, they were abducted in an undisclosed vehicle. That he found himself in Kisii the following morning, having lost 270,000 belonging to the first accused. Upon receiving this report, PW3 instructed the police officer then manning the report office, who testified as PW 24, to record the report in the station's occurrence book, which was done. And the extract of that report was produced in evidence as Prosecution Exhibit 35. After this report was recorded, PW 23 was made aware of the abduction report that had been made by PW 9 the previous evening at Cadell Police Post. And he formed the opinion that the report made by the second accused was suspicious, and the second accused was therefore arrested for further investigations. On the same day, at around 3 p.m., this is now the 4th of September 2018, Sharon's lifeless body was discovered in a bush near Owade River by Mr. Moses Oditi Oguta, a resident of Owade village. This Moses Oditi, who testified as PW 7, was shepherding his cattle towards his home when he stumbled upon Sharon's body. He reported the matter or this discovery at Oyugi's police station. He was escorted by police officers, namely Inspector Mary Mogire, PW 18, and PC Midiki, PW 19, to the scene where he had left his body, and they found members of the public already gathered. PW 18 and PW 19 recalled having noted that the body was naked, lying face down in a pool of blood. As part of her preliminary investigations, PW 18, this is Mary Mogire, recovered the items she found at the scene and prepared an inventory of the same. The items included items of clothing, and open shoes belonging to Sharon, 2 used condoms, 3 sachets of trust condoms, 2 cover packets of trust condoms, and a sachet of some illicit brew. PW18, Inspector Mary Mogire and PC Sami Midiki, after those preliminary investigations, collected the body and took it to Rachuonyo District Hospital mortuary for preservation. On the 8th of September 2018, according to the evidence of PW29, he identified the late Sharon's body to the government pathologist, Dr. Johansen Oduor, PW1, who conducted an autopsy on the body. In his testimony, PW1 recalled that on examining the body, he noted multiple external injuries consisting of 2 slash wounds under the right and left ear, and a total of 7 deep stab wounds, one at Sharon's abdominal area, and the others at several areas of her back. After his examination, he opined that the deceased's cause of death was severe hemorrhage due to penetrating force trauma with features of manual strangulation. He documented his findings in a postmortem report, which he produced as Exhibit 1. In the course of his examination, he also noted that the deceased uterus had a dead fetus, which was 28 weeks old. The stab wound to Sharon's abdomen had penetrated to the uterus, gone through the fetus's abdomen, and came out through the umbilicus. He also prepared and signed a postmortem form in respect of the fetus, which he produced as Exhibit 1B. Upon cross-examination by Mr. Kilukumi, Senior Counsel for the first accused, PW1 confirmed that with that kind of injury, the fetus did not have any chance of being born. As reports in both the mainstream and social media platforms started circulating regarding the circumstances in which Sharon and her unborn baby were found dead, and given the public interest the reports had generated, a team of officers from the Directorate of Criminal Investigations headquarters, that is DCI headquarters in Nairobi, was dispatched to Homa Bay to take over investigations into the matter. This team of officers included Chief Inspector Nicholas Konara Olesena, who testified as PW42, the last prosecution witness, and he narrated to the court how investigations in this case were undertaken by the investigating team from DCI headquarters. According to his evidence, together with his co-investigators, they arrived in Homa Bay on the 6th of October 2018 and commenced investigations. They found their second accused already under arrest. In the course of their investigations, they recorded and reviewed statements from persons who have testified as prosecution witnesses. And this included PW21, the health records and information officer at Kisii Teaching and Referral Hospital. This witness, that is PW21, confirmed that the medical records allegedly obtained by the second accused from PW20, purportedly issued by KTRH, did not emanate from the hospital, and they were in fact forgeries. He also recalled that he had obtained the forged medical records, that is PW42, claimed that he obtained these forged medical records at Oriri police station after the second accused had presented them there while making a report about his alleged abduction on the evening of that September 2018. PW42 also recalled having visited Gracia Hotel in the course of their investigations in a bid to obtain CCTV footage about the happenings of the 3rd of September. But he was unable to obtain any, as the device for storage of CCTV images, that is the DVR, was faulty. His investigations also led to recovery of motor vehicle KCL 481K, which had been used in the abduction of the late Sharon and PW9. After this vehicle was identified in court by PW9, he produced it in evidence in support of the prosecution case as PW as Exhibit 17. Further investigations led to analysis of DNA profiles generated from the first accused and baby Sharon, which, according to the government analyst, Mr. John Kimani Mugai, confirmed or revealed that the first accused was the biological father of baby Sharon. He produced a report documenting his findings dated 11th March 2020 as Exhibit 11. In the course of his investigations together with his team, PW42 caused forensic examination of mobile phones, including phones belonging to PW28, an iPhone belonging to the first accused, and Huawei tablet belonging to the deceased. The phones were produced as exhibits in this matter, and the cybercrime forensic report showing text messages and images contained in the aforesaid phones was also produced as Exhibit 51M. Notably, this forensic report showed that the iPhone belonging to the first accused had text messages for only 2 days. That is on the 12th and 13th of September 2018. PW42 also recalled having obtained call data records from 2 service providers, namely Airtel and Safaricom Limited, in respect of mobile mobile lines used by late Sharon, PW28, accused 1, accused 2, accused 3, and PW38, together with their M-Pesa records. The reports containing the above details were also produced in evidence by PW42 as exhibits. Another witness, that is PW41, produced, who was the liaison officer with Airtel Limited, produced subscriber details and call data records for the Airtel line, which was acquired by the second accused on the 27th of August. The subscriber details showed that the line was registered under the name of Vincent Abonyo, that who was a PW8. In the course of his investigations, PW42 also recorded a statement from PW39, that is who was the administrator in the car tracking firm known as Cool Point Services, which showed that the car tracking system fixed in motor vehicle registration number KCL 481, which is the vehicle that had been used in the abduction of PW9 and Sharon. Its tracking system was not functional on the 3rd of September 2018 and was only reactivated on the following day, the 4th of September. In her evidence, this was indicative of the fact that the tracking device had either been tampered with or was disabled by failing to record its SIM card with credit, or that it may have been also as a result of low signals. After winding up his investigations, PW42 recommended the prosecution of the 3 accused persons with the offenses charged in this case. At the close of the prosecution case, this court, in a ruling delivered on the 30th of January 2025, determined that the prosecution had established a prima facie case against the 3 accused persons in count 1 and put them on their defense in respect of that count. In respect of count number 2, however, the court found that by virtue of the bond alive principle, which was incorporated into Kenyan law by Section 214 of the Penal Code, baby Sharon, being a fetus which died in its mother's womb, did not fit the description of a person within the meaning of Section 203 of the Penal Code, which is the provision that creates the offense of murder. In the result, this court found that the accused persons did not have a case to answer in count 2, and each of them was accordingly acquitted or in respect of that count. When the accused persons were placed on their defense, each of them elected to give a sworn statement. The first and the third accused persons did not call additional witnesses, but the second accused called 2 witnesses. In his evidence, the first accused denied having committed the offenses alleged, or having conspired with the second and third accused persons, or any other person, to murder the deceased. He admitted having had an intimate sexual relationship with the deceased from November 2017, and that in February or March 2018, he decided to terminate the relationship, allegedly because he discovered that Sharon had lied to him about having a stationery and boutique business, and that she had also lied about the number of her children and the men in her life. He also testified that when Sharon informed him about her pregnancy in March 2018, although he had decided to terminate their relationship, he was comfortable with the pregnancy, and he continued giving her financial support for her upkeep and antenatal clinics, either directly or through the second accused or through Lawrence Muller, that is PW 28. He, however, admitted that he had grown distant and that the level of his financial support had dwindled. The first accused also supported PW9's testimony that sometimes in August 2018, he communicated with PW9 and gave him an appointment to visit him at his home in Rapogi. That PW9 honored the appointment and went to his home accompanied by PW28. The 3 of them had a meeting which was also attended by his spouse. He further recalled that in that meeting, PW9 threatened to publish his relationship with Sharon in the media, and that in his response, he told him to go ahead with his plans, as his family and his communication team already knew about it, and the information was in any event in the public domain through social media. Regarding his interactions with PW28, he admitted having had meetings with PW28 in Nairobi and having used him as an intermediary to channel funds to Sharon, in addition to the second accused. He also stated that through PW28, he managed to have the deceased abandon her earlier demands and accepted to have him buy her a plot in rural Homa Bay, in which he would construct and furnish for her a 3-bedroomed house. The first accused, however, admitted that this promise had not been fulfilled at the time Sharon unfortunately met her death. Lastly, the first accused raised an alibi, claiming that on the 3rd of September 2018, when the offense was committed, he was not in Migori, as he had already traveled to Nairobi by road on 2nd September 2018. He also claimed only got to PW9 and Sharon's abduction on the following day, after he was informed by his communications director about it. On his part, the second accused also denied having had any role in the death of Sharon and claimed that the prosecution witnesses had misrepresented facts. He, however, admitted that at the material time, he was working as the first accused's personal assistant, and that after he got to know Sharon and her relationship with the first accused, he became the liaison person between her, the first accused, and PW28. The first accused also used to send him with money to deliver to Sharon, either directly or through PW28. The second accused also admitted that on the 23rd of August 2018, he was in Nairobi together with the first accused on official duty, and that in the evening, he was at SIGNET Hotel, from where he sent 22,000 to PW9 through M-Pesa, through the M-Pesa account of PW4. He also admitted that this money was meant to facilitate Sharon's and PW9's travel to Nairobi on the following day. He claimed that the Nairobi meeting, had been scheduled or had been convened at Sharon's request, who had pleaded with him to schedule a meeting between her, PW9, PW28, and the governor, to have the governor resolve differences that had emerged between them. And that when PW9 and Sharon arrived in Nairobi on the 24th of August, he was accompanied by the third accused to meet them at Capital Center. He also recalled that accused number 3 also accompanied him to meet PW28 later during that day. The second accused also admitted having acquired an Airtel line, the line that was referred to by PW9 and PW22, allegedly at the request of the deceased to facilitate easier communication between them. He admitted that the line was not in his name, claiming that he bought it when it was already registered in another person's name. The accused also admitted having called Sharon, PW9 and PW28, telling them or instructing them to henceforth communicate with him only using that line. Regarding the events of that September 2018, The second accused testified that he spent the morning and afternoon performing official duties in Migori County, including preparations for an upcoming official trip to Rwanda. He denied having attended a meeting in Olivia's home in the morning, as alleged by PW 38. He, however, admitted having convened a meeting between him, Sharon, and PW9 that evening at the Grasha Hotel. At the hotel, he had discussions with Sharon and also delivered to her 100,000 which was the message he was meant to deliver from the first accused. He also admitted having left the hotel accompanied by Sharon and PW9, but denied that when they got to the parking area, he boarded the vehicle described by PW9, that is the vehicle that was being driven by PW 38, together with Sharon and PW9. PW9 and Sharon, according to him, boarded a black vehicle that make Toyota Wish. But he was left behind, and that the hotel's watchman thereafter flagged for him a motorcycle which took him to Rongo, from where he boarded a taxi to his home in Migori. According to the second accused, on the 4th of September 2018, he started his journey to Nairobi by road very early in the morning in order to catch a flight at JKIA for his planned official trip to Rwanda. While near Kisii, he received a call from the Migori County Communications Director asking him to check social media reports which were implicating him in the abduction of Sharon and PW9. He claimed that he was instructed to report to Migori Police Station. Upon receipt of this information, he aborted his trip to Nairobi, drove to the governor's office in Migori, deposited money for his per diem, but instead of reporting to Migori Police Station as instructed, for undisclosed reasons, he presented himself at Oriri Police Station, where he was arrested. He denied having made any abduction report at Oriri Police Station on the 4th of September 2018 as alleged by PW23, or having had any interaction with PW22 regarding preparation and issuance of forged medical records. He also denied having attended a meeting in Olivia's home on 3rd of September 2018. He maintained that his role in matters pertaining to Sharon and the first accused was limited to that of a messenger, looking out for Sharon's well-being. As stated earlier, the second accused called two witnesses, the first one being Mr. Omodi Elvis Okoth, who testified as defense witness 3. This witness admitted that he was at the time serving as one of the first accused bodyguards, and that he had served him in that capacity for 10 years. He also admitted he denied. He admitted knowing Olivia, that is the third accused wife, but denied having attended a meeting in her home on the morning of that September 2018. He denied that he knew Sharon, claiming that he only learned about her after her death. The second witness, Mr. Patrick Ngamwangi, testified as defense witness 4 and claimed that he was the principal officer in Quantum Motor Assessors and Valuers, a firm dealing with accident assessments and valuation of vehicles. He gave his qualifications as a diploma in automotive engineering from the Kenya Polytechnic and a certificate of proficiency in insurance from the College of Insurance. This witness recalled having received instructions from the law firm of Professor Otieno Gender and Associates, seeking expert opinion on the likely consequences of a passenger who was of average height with a lean and athletic body, jumping from a vehicle moving at a speed of between 80 and 100 kilometers per hour, landing on the tarmac. After researching on this brief, he formed his opinion that such a passenger would be expected to sustain extensive and severe injuries, including fractures or death. He documented his opinion in a report which he produced as Defense Exhibit 5B. Upon being cross-examined by Ms. Gekoi for the state, he admitted that his expertise was only limited to motor vehicle assessments, but not medical injuries in the kind of scenario referred to him by the second accused advocates. He also admitted that before preparing his report, he did not conduct any demonstrations, simulations, or reconstructions of the scene using any devices to determine possible outcomes. He instead relied on sketches that he did not produce before the court. The third accused testified as defense witness 5. He also denied having committed the offense as alleged, but he admitted that in the year 2018, he worked at Migori County as a clerical officer, and that Olivia was his second wife and owner of motor vehicle registration number KCL 481K. He claimed that he denied that he was at Olivia's home during the day, claiming that he spent the entire day at his place of work and only went to her home in the evening. He further testified that he met the late Sharon only once, when he accompanied the second accused to a meeting in Homa Bay town, in which the deceased was a participant. He added that he did not have any personal interactions with Sharon and did not even know about her relationship with the first accused until he read about it in the social media. He, however, did not clarify whether this was before or after Sharon's demise. The third accused also denied having contacted PW22 on the 1st September 2018 or requesting him to procure false medical reports for the second accused. He also denied having seen the second accused on that day. Upon cross-examination by Ms. Gekoi for the prosecution, accused 3 confirmed that between 2013 and 2018, he was based at the Migori Governor's Office. He also recalled having accompanied the second accused to Capital Center on the 24th of August when he had gone to meet Sharon and PW9. He also confirmed that in his statement to the police, he had admitted that he was at Olivia's wife. He was at Olivia's home, that is his second wife's house, on the 3rd September 2018 at around lunchtime or around midday. In addition, he confirmed that Mr. Gombe, PW38, had been the driver of the subject vehicle, that is KCL 481K, since it was bought by his wife in 2017. After the close of the defense case, landed counsel on record for the parties filed lengthy and very elaborate final written submissions, which I have duly considered, together with all the authorities cited. And having carefully considered the evidence adduced by the prosecution and the defense in this case in its entirety, together with the written submissions filed on behalf of all the parties, I find that the only issue arising for my determination is whether the prosecution had proved to the required standard required by the law that the 3 accused persons, whether by themselves or jointly with others not before the court, murdered Sharon Beryl Otieno as alleged. The offense of murder is created under Section 203 of the Penal Code, which stipulates that any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. A plain reading of the above provision reveals that the offense of murder has 3 essential ingredients which the prosecution must prove beyond any reasonable doubt before it can secure a conviction. The 3 ingredients of this offense have been identified in numerous authorities, which I need not rehash here. It will suffice to cite the authority of Anthony Degwa Gary versus Republic, in which the Court of Appeal held as follows: that the 3 elements of the offense of murder, which must be proved beyond reasonable doubt, were as follows: the death of the deceased and the cause of that death, that the accused committed the unlawful act which caused the death of the deceased, and that the accused had the malice aforethought. It is clear from the provisions of Section 203 and the foregoing authority that the key ingredients of murder are as follows: proof of the deceased, that the death was caused by an unlawful act, and that the accused, with malice aforethought, committed the unlawful act which caused death of the deceased. In general criminal jurisprudence, it is right that for a crime to be committed, there has to be a criminal act accompanied by a guilty mind. As correctly observed by Lord Kenyon in Flower versus Paget, and I quote, "To constitute a crime, there must be, as a general rule, both a guilty mind and a criminal act." In other words, the criminal act, otherwise known as the actus reus, and the guilty mind, or the criminal intent, known as mens rea, must converge for a crime to be committed. For the offense of murder, the actus reus is the unlawful taking of another person's life, while the mens rea is malice aforethought. Malice aforethought is a state of mind that denotes culpability or moral blameworthiness on the part of the person accused of murder. Section 206 of the Penal Code sets out the circumstances in which malice aforethought can be ascertained. And it can be ascertained by proving or establishing any or more of the following circumstances. The first one, an intention to cause the death of or to do grievous harm to any person, whether that person is the person actually killed or not. Knowledge that the act or omission causing the death will probably cause the death or grievous harm of some other person, whether that person is the person actually killed or not. The intent to commit a felony, an intention by the act or omission to facilitate the flight or escape from custody of any person who had committed or attempted to commit a felony. Before addressing the issue isolated above for my determination, I think it is important to point out at the outset that in criminal cases, the prosecution bears the burden of proving the guilt of an accused person beyond any reasonable doubt. This burden is anchored on the cardinal principle of the law of evidence as set out in Section 107(1) of the Evidence Act, which states that, and I quote, "Whoever desires any court to give judgment as to any right or liability dependent on the existence of facts which he asserts must prove that those facts exist." As far as criminal cases are concerned, the prosecution's burden of proof is entrenched in Article 50, Subarticle 2A of the Constitution of Kenya, 2010, which guarantees to every accused person the right to be presumed innocent until the contrary is proved. The standard of proof in criminal cases, which, as I noted earlier, is proof beyond reasonable doubt, was defined by Lord Denning in the case of Miller versus Minister of Pensions in the following terms, and I quote, "Proof beyond reasonable doubt does not mean proof beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. if the evidence is so strong against a man as to leave only a remote possibility in his favor, which can be dismissed with a sentence, of course it is possible, but not in the least probable. The case is proved beyond reasonable doubt. What that definition means, in my view, is that not every doubt amounts to reasonable doubt as envisaged by the law. From the foregoing, it is clear that reasonable doubt will have been created if, at the conclusion of a trial, the trial court was persuaded to find that there was a real or high probability that the accused person did not commit the offenses charged. In such a case, the prosecution would have failed to prove its case against the accused person, and the accused person would be entitled to an acquittal. Having set out the law on what constitutes the prosecution's burden and standard of proof, I now turn to address my mind to the question whether the prosecution has established in this case the essential elements of the offense of murder against the accused persons. Starting with whether the deceased death occurred and whether or not it was unlawful. From my analysis of the evidence adduced by both the prosecution and the defense, as well as the written submissions filed on behalf of the parties, I find that the death of Sharon was not contested by any of the accused persons. In any event, it was proved through the evidence of PW7, who discovered Sharon's lifeless body near Owade Bridge on 4th of September 2018. It was also proved by the evidence of PW18 and PW19, who collected the body from the scene, and PW29, who identified it to the police pathologist, PW1, who conducted the postmortem. There is therefore no doubt that the death of the deceased occurred as alleged. The next question to determine is whether the deceased's death was lawful or unlawful. In this regard, Article 26, subsection 1 of the Constitution is relevant. This provision guarantees to every person the right to life and proceeds to decree at Subarticle 3 that a person shall not be deprived of life intentionally, except to the extent authorized by the Constitution or other written law. In my view, the import of the above constitutional provision is that there are some homicides which are excusable in law, such as those that are sanctioned by the law. For example, the death penalty, or those resulting from accident or inadvertence. In the case of Gusabizi Wesonga versus Republic, the court gave guidance on what may constitute lawful homicide, and held as follows, and I quote, "Every homicide is presumed to be unlawful, except where circumstances make it excusable, or where it has been authorized by the law. For a homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or property." In the instant case, it is clear from the evidence of PW1, that is the police pathologist, that the deceased or the late Sharon died as a result of multiple and severe injuries in the form of deep stab wounds inflicted on different parts of her body, which were mainly targeted at her vital organs, including her abdomen, which housed her unborn baby. According to the evidence of PW1, her death was severe. The cause of her death was severe hemorrhage due to penetrating force trauma with features of manual strangulation. Given this evidence, which was not contested, it is my finding that the prosecution has proved beyond reasonable doubt that the deceased's death was not caused by natural causes, and it was not as a result of an accident or inadvertence. I do not therefore have any hesitation in finding that Sharon's death was unlawful. The singular question now left for my determination is whether the accused persons, with malice aforethought, participated in the unlawful killing of the late Sharon. As correctly submitted by learned counsel representing each of the accused persons, the prosecution's case in this case is solely based on circumstantial evidence. This is so because none of the 42 witnesses who testified in support of the prosecution case gave direct evidence regarding how the deceased met her untimely death. None of them claimed to have witnessed the unlawful killing of Sharon. This being the case, I think it is important to understand what circumstantial evidence entails and the threshold set by the law for it to sustain a safe conviction. Circumstantial evidence is evidence of surrounding facts and circumstances from which the existence of a fact in issue may reasonably be inferred. It does not directly establish the fact to be proved, but it leads to its proof through a process of logical inference. The Evidence Act, Chapter 40, Chapter 80 of the Laws of Kenya does not distinguish between direct and circumstantial evidence with respect to admissibility. Both types of evidence are competent and may sustain a conviction if they meet the threshold of proof beyond reasonable doubt. The Supreme Court of Kenya in Republic versus Ahmed Abdul Fathi Mohammed and another comprehensively unpacked what constituted circumstantial evidence and its application. I have reproduced some extract from this evidence, which is a long quote, which I think I need not read in the interest of time. It is settled law that for circumstantial evidence to sustain a conviction, it must consist of credible and cogent evidence, which irresistibly pointed to the conclusion that the accused person and nobody else committed the offense charged. The circumstances should be firmly established in a way that they formed a chain so complete that they were incapable of any other hypothesis other than the guilt of the accused person is charged. The above legal position was also succinctly articulated by the Court of Appeal in the case of Save versus Republic, and the court expressed itself as follows, and I quote, "In order to justify a conviction on circumstantial evidence, the inference of guilt, the inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other reasonable hypothesis than that of his guilt. There must be no other coexisting circumstance weakening the chain of circumstances relied upon. The burden of proving facts that justify the drawing of this inference from the facts to the exclusion of any other reasonable hypothesis of innocence remain with the prosecution. It is a burden which never shifts to the party accused." In denying the offense, each accused person denied having played any role in planning or causing the death of the late Sharon. The first accused, as noted earlier, maintained that he had no motive or reason to cause the death of Sharon, which was demonstrated by the fact that even after terminating his relationship with her, he continued providing her with financial support to ensure her upkeep and general well-being, including her pregnancy to the very end. According to the first accused, a further demonstration that he had no motive to end the life of Sharon was that his intimate relationship with her was at the time an open secret, as it was within the knowledge of members of his family, and it was already in the public domain. The second accused, on the other hand, also asserted that the only role he played in matters concerning Sharon was the role of a messenger to convey money and other communication from the first accused to ensure her welfare. That for this reason, he did not also have any motive to kill her. On his part, the third accused claimed that he barely knew Sharon, as he had only met her once, and he therefore did not have any reason to be involved in her death. In view of the assertions made by the accused persons regarding lack of motive to kill the late Sharon, I find it necessary at this juncture to address the issue of motive and its place in criminal responsibility. Motive, simply put, is the reason for committing an offense. It is provided for under Section 9(3) of the Penal Code as follows. Unless otherwise, and I quote, unless otherwise expressly declared, the motive by which a person is induced to do or to omit to do an act or to form an intention is immaterial so far as regards criminal responsibility. When discussing motive, the Court of Appeal in Limabula versus Republic noted that proof of motive is not essential to prove a crime, but may be relevant, particularly in cases resting on circumstantial evidence. With specific reference to the offense of murder, the same court also held in Robert Onchiri Ogeto versus Republic that proof of motive was not essential to prove malice aforethought. The court held that the prosecution, and the court held, as I quote, the prosecution does not have to prove the motive for commission of any crime. Neither is evidence of motive sufficient by itself to prove the commission of a crime by the person who possesses the motive. By virtue of Section 206A of the Penal Code, malice aforethought is deemed to be established by evidence showing an intention to cause death or to do grievous harm. It can be reasonably inferred that when the appellant, now referring to the context in which this case was decided, when the appellant stabbed the deceased with a knife on the chest, he intended to cause death or grievous harm to the deceased. And for that being the case, the court was satisfied that the appellant was properly convicted for the offense of murder, even though motive had not been proved. Regarding the doctrine of common intention, which is the centerpiece or lies at the heart of the prosecution's case, the doctrine is codified in our law under Section 21 of the Penal Code, which provides that when two or more persons form a common intention to prosecute an unlawful purpose in conjunction with another one, in conjunction with one another, and in the prosecution of such purpose, an offense is committed of such a nature that its commission was a probable consequence of the prosecution of that purpose, each of them is deemed to have committed the offense. In Joroge versus Republic, the Court of Appeal confirmed that the applicability of this doctrine does not require proof of an express agreement. It may be inferred from conduct, presence, and participation of the accused persons before, during, and after commission of a crime. The level of participation, even though minimal, or the role played by each offender, even though insignificant, attracted full criminal responsibility if done in furtherance of the common criminal intention. The above principle, read together with the definition of principal offenders set out in Section 20 of the Penal Code, ensures that criminal liability attached equally to all those who contributed to a joint criminal enterprise. Section 20 of the Penal Code provides that criminal liability applies equally to all persons who actually commit the act constituting the offense, and to persons who aids or abets another person in committing the offense, or procures another person to commit an offense. This category of persons are the persons who the law recognizes to be principal offenders. In this case, the first accused admitted the prosecution's claim that he had an intimate sexual relationship with Sharon, as a result of which she became pregnant for him. Although I wholly concur with the first accused's submission that impregnating a consenting young lady of age was not a criminal offense. It is clear from the totality of the evidence adduced in this case that this particular pregnancy formed the basis of subsequent events which culminated into the unlawful death of the deceased. My thorough analysis of the evidence adduced by both the prosecution and the defense shows that the first accused claim that he had accepted the deceased's pregnancy or that he was comfortable with it, which in his view was demonstrated by the fact that he had continued to give her financial support for her upkeep and to nurture her pregnancy, even though he had terminated their relationship, was, in my considered opinion, actually not sincere and was not true. I make this finding because there is evidence from PW9 and PW30, Sharon's mother, which evidence was not expressly challenged by the first accused. That the first accused had actually exerted pressure on Sharon to abort the pregnancy and had proceeded to give her 30,000 for that purpose, which pressure Sharon refused to succumb to, following advice from her mother. Granted, it may be true that part of the reasons that the first accused decided to terminate his relationship with Sharon was his discovery that she had allegedly lied to him about having a business in her family life. But on the first accused's own admission, he learned about Sharon's pregnancy in March of 2018. And this is the same time he claims to have terminated or decided to terminate his relationship with the late Sharon. In his admission also, and from the account given by PW28 and also PW30, who is Sharon's mother. From that time, the first accused confirms that he became evasive and withdrew his financial support. And according from the account given by PW28, it is apparent that the first accused actually withdrew, withdrew, but did not reduce the financial support he used to give to Sharon, considering that, according to PW28, the Sharon was reduced to asking him for assistance, for money for her needs. And she was also forced to seek his intervention in identifying a journalist to make her plight public. If indeed the first accused was the magnanimous, considerate, responsible, and caring man he presented himself to be, and he genuinely intended to give Sharon both financial and material support throughout her pregnancy, as he alleged, my take is that he would not have distanced himself, refused to pick up her calls, and withdrew his support from March until July of 2018, when PW1 appeared at the scene with imminent threats of publishing his illicit affair in the mainstream media. It cannot be mere coincidence that the first accused suddenly developed interest in the deceased's well-being and that of her unborn child when Sharon's decision to cause publication of their illicit relationship in the print media was communicated to him by PW9 in the presence of PW28. The first accused was emphatic in his defense that he was not at all concerned about the deceased's threat to publicize their love affair in public, because in any event, it was an open secret, as it was already in the public domain, and members of his family knew about it. And although it may be true that members of his family and some members of staff of the Migori County government knew about the affair, as claimed by PW42, the investigating officer, it cannot be entirely true that all members of the public in the country who held the first accused in high esteem as the political head of the county government of Migori actually knew about it. For instance, PW28, who was a resident of Homa Bay, did not know about this relationship until Sharon herself told him about it. There is also evidence that even though claiming that his relationship with Sharon was already in the public domain, the first accused clearly wanted to contain it within the scope it had reached and prevent it from further spreading to contain it in the scope within which it was, because to illustrate this point, I would refer to the evidence of PW9 relating to what the first accused told him when he was leaving his Rapogi home after the meeting. And this is what PW9 claims that the first accused told him, and I quote, "The governor then escorted us outside the main house. We stood at the staircase. He bade us goodbye and promised to keep in touch after instructing me not to tell anybody about Sharon's pregnancy." This particular aspect of PW9's testimony was not expressly challenged by the first accused. Further, when under cross-examination by counsel for the victim's family, PW28, who the first accused admitted was a truthful witness, recalled having stated in his witness statement that when in a meeting with the second accused outside Tausi Hotel, the second accused had asked him how they could get access to the deceased's and PW1's handsets, since they contained evidence that could take the governor to the media. The second accused was not involved in the information in the handsets, as reviewed by the evidence adduced in this case. And the concern he raised about this information getting to the media must have emanated from the first accused. From the above evidence and considering the exorbitant demands that the late Sharon had made to the first accused as a precondition to withholding her intention of going to the media with her story, I am persuaded to agree with the prosecution's submissions that the various amounts of money conveyed from the first accused to the deceased, either through PW28 or the second accused, were not genuinely intended to promote her well-being, but were designed to contain, to manage, and to delay, or to make Sharon abandon her intention to publicize her affair with the first accused as a scheme to eliminate her and to silence PW9 was being devised. The same argument applies to the first accused's promise to buy a plot and construct a 3-bedroomed house for Sharon in Homa Bay, since the promise was yet to be fulfilled by the time she met her untimely death. From the totality of the evidence adduced in this case, it is my considered view that the first accused had a very strong motive to unlawfully end Sharon's life, to ensure that his illicit affair with her was not widely publicized through the print media, in order to save himself from possible public embarrassment and reputational harm, and to safeguard his political standing. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot. Sorry, let me go read this again. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot, as he was likely to suffer if the deceased actualized her threat of publishing them in the media her story regarding their illicit love affair. In the premises, I am persuaded to agree. I'm persuaded to agree that in order to eradicate the imminent threat of having the possibility of having his name or reputation dragged through the mud by publication in the mainstream media of this relationship with Sharon, the first accused instigated a scheme to eliminate Sharon and using his influence as the governor of Migori County, he enlisted the services of his trusted aides, the second accused, who was his personal assistant, and the third accused, who worked as a clerical officer in the county government of Migori. This must be why, in my view, the first accused insisted to PW9 and to PW28 that all matters concerning Sharon's pregnancy should be directed to the second accused. And he consistently used the second accused as his intermediary with Sharon, PW9 and PW28. From the evidence, it is clear that the second accused embraced the role he had been assigned by the first accused. Because besides delivering money and other messages to Sharon, and sometimes to PW28 on behalf of the first accused, he also wanted or instructed PW9 and PW28 to keep off all matters related to Sharon, as he would henceforth deal with them. This finding is also strengthened by the evidence also adduced by the prosecution, which demonstrate or which shows that accused number 2 also embarked on activities meant to disguise or conceal his communication with Sharon, PW9 and PW22, as well as M-Pesa transactions. And this happened prior to the commission of the offense. This evidence is demonstrated by the evidence, which was also admitted by the second accused, that on the 23rd of August 2018, he planned a visit to Nairobi by PW9, PW28 and Sharon, promising to schedule a meeting with the first accused. The first accused, as the evidence shows, was at the time attending a Council of Governors meeting in Nairobi. To facilitate the meeting, the second accused sent to PW9 22,000 to finance their travel with Sharon to Nairobi. But in doing so, he did not use his M-Pesa account. Instead, he chose to use the Safaricom line of PW4 to send the money, allegedly because he did not have his identity card at the time, which was required to effect the transaction. However, the reason given by the second accused for failure to use his M-Pesa account to make this transaction was disputed or refuted by PW4, who claimed that the reason given by the customer who requested her to use her M-Pesa line to send this money, who turned out to be the second accused, was because the customer claimed that he did not have a Safaricom line. This juxtaposed with the second accused's evidence that he actually had an active Safaricom line goes to prove that in using this using PW4's Safaricom line, the second accused was motivated by an intention of concealing his identity, which only means that he had a reason for wanting to have his identity concealed so that this transaction would not be linked to him in the event that there were some investigations that concerned the transaction or that concerned whatever schemes that were motivating this kind of dealing. I make this finding because I have no reason to doubt the evidence of PW4 because in my view, she was a completely independent witness as she did not know the second accused, and she did not therefore have any reason to give false evidence against him. So it is therefore my finding that the only reason that the second accused would want to conceal his identity was to avoid being linked to the Nairobi visit because it must have been planned for an illegal purpose. Another strand of circumstantial evidence adduced by the prosecution is that on the 27th of August 2018, the second accused acquired an Airtel line number 0739473321, which, in my view, was also aimed at disguising his communication with Sharon, PW1 and 28, and concealing his identity. According to the prosecution's evidence, which was not also disputed by the defense, this line was registered using an identity card earlier stolen from Vincent Abonyo, who testified as PW8. And after acquiring this line, the second accused immediately disseminated it to PW9 and to PW28 with instructions that this is the only line they should henceforth use when communicating with him. In his defense, the second accused admitted having acquired this line, but denied having fraudulently registered it using a stolen identity card, claiming that he acquired it when it was already registered in PW8's name. He also admitted that he acquired this line for exclusive communication between him, the deceased PW9 and PW8. But he continued using his regular Safaricom and Airtel lines to communicate with every other person. The second accused claimed that he acquired this line when it was already registered in PW8's name cannot be true because according to PW26, in order to acquire an Airtel line, the person seeking that acquisition had to register the SIM card using an identity card. PW26 also recalled that the person who registered their forwarded line, who he could not remember, actually registered this line using an identity card issued in the name of Vincent Abonyo. PW26 evidence was not shaken in cross-examination by the second accused. And I am convinced that his evidence represented the factual position regarding how the second accused acquired that Airtel line. The fact that drawing from the foregoing, or drawing from that evidence, I am satisfied that the second accused fraudulently acquired the Airtel line for the sole objective of concealing his communication with the deceased, PW9 and PW28, so that any such communication would in future not be traced to him. His inconsistent explanations to PW9 and PW28 regarding the reason he had procured the line demonstrates lack of truthfulness and undermines the credibility of his testimony. More importantly, the fact that the line was fraudulently acquired just days before Sharon's murder, coupled with the second accused's insistence that the line be used as the exclusive channel of communication between Sharon, PW9, and PW28, the only two people who had become Sharon's close associates, leads me to an irresistible inference that this line was acquired as part of acts of preparation for commission of the offense. Regarding the events of that September 2018, which needless to state is the date that Sharon was abducted and subsequently killed, the prosecution led evidence seeking to prove that there was a preparatory meeting held at the third accused's wife's home, that is Olivia's home, in the morning. PW38 testified that he found the third accused seated outside the home in an apparent meeting with one Dicky, Olivia, with one Dicky. Olivia and Elvis were inside the house. PW38 had gone to the house to pick a copy of the subject vehicle's logbook to facilitate its valuation. In his evidence at a cross-examination, PW38 clarified that he had confused the time that he had gone to the home, that it must have been after 12 or 3 p.m., since he went to the home after talking to Olivia. The second and third accused denied having attended any such meeting, claiming that they did not leave their places of work on that day. At a cross-examination, however, the third accused recalled that in his statement to the police, he had actually admitted that he was at Olivia's home on that day around midday. Although the second accused claimed that on that day he was busy in his office preparing for an official trip to Rwanda on the following day, the email correspondence from the travel agent, which he produced as a defense exhibit 4, indicated that as late as 12:59 p.m. His ticket to Rwanda had not been confirmed, as it was still on the waiting list. Elvis, who testified as defense witness 4, also denied having been present at Olivia's home at the time alleged. I must state that in my assessment, I found Elvis struck me as an untruthful witness, considering that he claimed in his evidence that he did not know Sharon or her relationship with the first accused, despite the fact that there was evidence which he admitted that he had been one of the first accused's bodyguards and had worked in that capacity for 10 years. In the circumstances, his claim that he was not aware of that relationship was implausible and can only mean that he cannot be taken to have been a credible witness. I therefore do not give any weight to his claim, to his evidence. Continuing with evidence adduced relating to the events of that September 2018, the prosecution also tendered evidence through the evidence of PW9 and PW13, PW38, to prove that the second accused convened a meeting with Sharon and PW9 at Gracia Hotel in the evening. This meeting, as noted earlier, was acknowledged by the second accused in his evidence, and he admitted having met Sharon and PW9 in that hotel to deliver a message from the first accused. There is also evidence which was also admitted by the second accused that he left this hotel together with Sharon and PW9, and although there was conflicting evidence between the evidence given by PW9 and PW38 regarding the manner in which these two witnesses, Sharon and PW9, together with the second accused, left the hotel. There is evidence that PW9 and Sharon boarded the vehicle that was being driven by PW38. Whereas there is, according to PW9, the second accused also boarded the same vehicle. There is evidence that this is the vehicle in which the second accused, Sharon and PW9, were allegedly kidnapped, and the vehicle that and it is this vehicle that transported the late Sharon to the scene in which she was subsequently killed. I have noted the discrepancy between PW9's and PW38's evidence regarding whether or not the second accused boarded the subject motor vehicle. In my mind, while the accounts of PW9 and PW38 differ on the precise sequence of how they left the scene, they converge on the critical point that on the 3rd of September 2018, the second accused was with the deceased in PW9 at Gracia Hotel in the company of unidentified men, and the final point of separation was either at the hotel gate or the roadside near the petrol station. Whether the second accused boarded the vehicle at the hotel or joined them later is immaterial. Both witnesses confirm that he was present and was involved at the precise moment. And although the second accused in his defense denied knowledge of or any association with the unidentified men, he did not challenge the evidence of PW9 and PW38 about the presence of these unidentified men or his association with them. It is important to mention that in their written submissions, learned counsel for each of the accused persons submitted at length on their foregoing contradictions and strongly attacked the credibility of PW9 and PW38, asserting that their evidence was planted and was fabricated. The attack on PW9's credibility was mainly two-pronged. First, it was admitted that he was not a truthful witness because he had earlier described the motor vehicle used in his and Sharon's abduction as black. But when the vehicle was produced in court for identification, it turned out that it was grey in color. Secondly, it was admitted that it was not possible for him to have jumped out of a moving vehicle, allegedly traveling at a speed of 80 kilometers per hour, and survived with only minor injuries, without serious fractures. The challenge on PW38 was to the effect that he was a planted witness because his evidence was full of falsehoods, and the court was urged to find that his evidence ought not to be believed because he gave different statements to the police during investigations, some of which differed with the evidence that he gave to the court. The test used by courts to determine the impact of contradictions or inconsistencies on the prosecution's case is a substantive one. It requires the court to inquire whether the contradictions or consistencies were so material to the issues in question that they would deal a fatal blow to the prosecution case. In the case of Eric Onyango Odeng versus Republic, the Court of Appeal held that minor discrepancies and inconsistencies in the evidence of prosecution witnesses were natural and inevitable, where different witnesses recounted the same events from different perspectives. Such inconsistencies would not render the prosecution's case unreliable unless they were material and go to the root of the charge, or that they created reasonable doubt as to the guilt of the accused, or demonstrated deliberate falsehood. The Court of Appeal guided that only grave and unexplained contradictions that affect the substance of the prosecution's case may justify rejecting the evidence. I have keenly considered the contradictions which the defense has made very heavy weather of during cross-examination and in their submissions. I find that the contradictions in the evidence of PW9 and PW38 related to whether the second mainly related to whether the second accused boarded the vehicle at the hotel, whether the vehicle had music, and whether the late Sharon expressed distress when the vehicle was on transit. In my opinion, these contradictions related to peripheral matters that did not go to the root of the prosecution case. With respect to the contradictions in PW9's evidence, PW9 explained that he had described the subject vehicle as dark stroke black, because he had seen it at night in circumstances that did not allow to see its color properly. This explanation in my view is reasonable and does not, this explanation is in my view reasonable and does not indicate or is not evidence of any dishonesty or untruthfulness in the evidence of PW9, because even considering ordinary circumstances, Calagre fits the description of dark. Considering that even in ordinary circumstances, Calagre fits the description of a dark as opposed to a bright color, like white, cream, yellow, orange, or whatever other bright color you can think about, and may look like black whenever viewed in the darkness. In any event, it is common knowledge that a vehicle is identified through its registration number and not through its color. In my considered view, the contradictions in PW9 and PW38's evidence were not fundamental to the key issues in question in this case, and were thus not fatal to the prosecution case. Regarding the challenge on PW9's and PW38's credibility, contrary to the defense's submissions, I find nothing on record that would cast aspersions on the credibility of these witnesses. I watched the witnesses as they testified, and in my view, they gave clear, detailed, and consistent eyewitness accounts of the events that took place on that September 2018. PW38 explained that the few contradictions in the various statements he recorded with the police were as a result of the structured approach used by the investigating officers, which restricted him to answering only questions put to him. And these contradictions in that context cannot be viewed as indicative of untruthfulness on the part of the of PW38. With respect to PW9's evidence, his claim that he escaped from the subject vehicle when it was in motion was materially corroborated by PW27, in whose home he sought refuge, PW6, who recorded his abduction report at Kadeo Police Post, and PW9, who treated him for his injuries. PW27's evidence regarding how PW9 stormed into his house out of breath, visibly shaken and in a panic, and the fact that the first instinct of PW9 was to hide under a bed is quite telling. In addition, the description by PW6 and PW10, PW6 was the police officer who recorded his PW9's report at Kadeo Police Post. PW10 was the clinical officer who treated him. And the fact that these two witnesses confirmed in their evidence that when they saw PW9, he was visibly shaking to an extent that he was trembling when he was recording his statement or when he was being treated. These accounts by these two witnesses reinforced PW9's claim that he had just escaped from a life-threatening situation. Additionally, in the course of the trial, PW9 demonstrated to the court how he had managed to jump out from the moving vehicle, which according to PW38 had been moving at a speed of 60 kilometers per hour approximately, and not 80 kilometers per hour as alleged by the defense. Further, PW4's attempt to discredit PW9's evidence on this point dismally failed, because since he admitted that his expertise was only limited to motor vehicle assessments, he was not an expert on the law of motion in his own admission, and that he was not, in his admission, his only expertise related to motor vehicle assessments, and he was not therefore an expert on the law of motion and assessment of impacts that would be expected of a person or an object falling from a moving motor vehicle. Having satisfied myself that PW9 and PW38 were in fact credible witnesses, I find that the prosecution has proved beyond any doubt that the second accused was present at Gracia Hotel and at the nearby Olivia petrol station in the company of unidentified men who boarded motor vehicle registration number KCL 481K, who joined PW9 and Sharon. There is uncontested evidence that the unidentified men were the culprits who abducted, sexually assaulted, and eventually killed the late Sharon. Given the above evidence, I strongly take the view that the meeting at Gracia Hotel was not genuinely intended to convey the first accused's message to the deceased and PW9, but was in reality a deliberate entrapment to hand over the deceased to her killers or to her assailants. Additionally, the above evidence also demonstrated that the first accused, although physically absent, must have been aware at the meeting at Gracia Hotel, since in the second accused's admission, he's the one who had sent him to deliver money to Sharon in that hotel. It is also apparent that according to PW9 and PW38, the conversations that these unidentified men had with the late Sharon and PW9 led the conversations that these unidentified men had with the late Sharon and PW9, according to PW9 and PW38, who I have already found were credible witnesses, gave an inference that these unidentified men had some linkage to the first accused and appeared intent on protecting him, considering that they questioned Sharon and PW9 regarding their relationship with the first accused and why PW9 was following a story about the first accused. Turning now to the alleged involvement of PW9 in the evidence adduced by the prosecution, seeking to prove or seeking to establish the third accused. Turning now to the evidence adduced by the prosecution, seeking to establish the third accused's alleged involvement in having a scheme to unlawfully kill Sharon, I find that in his defense, the third accused denied having played any role in Sharon's death. And as noted earlier, he emphasized that he did not have any reason to be involved in her death because he even barely knew her. But he admitted having accompanied the second accused to meetings in which the late Sharon was involved twice. The first meeting was in a hotel at Homa Bay, when the second accused was delivering money to Sharon on behalf of the first accused, and the second one was at Capital Center during the Nairobi visit. The prosecution also linked the third accused to the commission of this offense because by the fact that the vehicle used in the abduction and eventual transportation of Sharon to the place in which she met her death was owned by Olivia, who was his second wife. PW39 confirmed in her evidence that the third accused's wife had been given access to the tracking device in the subject motor vehicle through a letter she produced in evidence as Prosecution Exhibit 53C, and that between 3rd September 2018 and the morning of the 4th September, the tracking device was not working, and indicating that it was either tampered with or disabled by failing to load its SIM card with airtime. It must be remembered that the 3rd September is the day that the late Sharon was killed. The fact that the tracking device failed at the very time that the vehicle in which Sharon was abducted was being used for the commission of an offense, for the commission of the offense, cannot be a case of mere coincidence. The two explanations given by PW9 regarding why the tracking device would cease functioning involved deliberate human intervention. Which means that the disablement of this tracking device was not a matter of a technological failure or something to that effect. Interference with this device on the day that Sharon was abducted and later killed is a strong basis upon which a strong inference can be made with regard to the preparation and concealment of the purpose for which this device was made unfunctionable. It demonstrated planning and intention to avoid detection. The prosecution also adduced evidence to prove that on the 4th September 2018, a day after the offense was committed, the third accused introduced the second accused to PW22, requesting him to procure fake medical records, which were generated by PW20 on the request by PW22. It is apparent from the above fabricated medical reports that they were meant to support a report made at Oriri Police Station to PW3 on the same day by the second accused, claiming that he had been abducted by unknown people on the previous evening, in the course of which he had been beaten and robbed. Investigations revealed that this report by the second accused was a false report. And this is what meant to his arrest at Oriri Police Station. And though though both the second and third accused persons denied having ever requested PW22 for procurement of these false medical reports, they failed to explain how the said documents bore the second accused's name and personal details. Importantly, the second accused did not disown those details. The submissions made on behalf of the two accused persons impugning PW22's evidence on grounds that he had handed over the documents to the second accused at around midday, when the second accused was already at Oriri police station, are, in my view, with a lot of respect, misplaced. They appear to be based on a misapprehension of PW22's evidence. PW22 clearly stated in his evidence that he handed over the fake medical records to the third accused on instructions by the second accused. He did not say in his evidence that he had handed over the documents to the second accused. In my view, the denial by the second and third accused that the denial by the second and third accused of involvement in the procurement of the forged medical records amounted to mere denials or afterthoughts, which did not affect the veracity of the two prosecution witnesses. These witnesses were independent witnesses in this case, and no reason was given by either the first or second accused that they had any reason to fabricate or give false evidence against them, against the two accused persons. That said, I agree with the second accused that PW42's claim, that is the investigating officer's claim, that that the second accused is the person who presented the false medical report or the false medical records to Oriri police station when making his abduction report, and that the investigating officer collected the medical reports from Oriri police station in the course of his investigations cannot be true. This claim by PW42 was not supported by the rest of the evidence on record. There is evidence from the arresting officers at Oriri police station that at the time the accused was arrested, he was searched, and nothing in the nature of documents were found in his possession. The other reason that I have made a finding that PW42's evidence on that aspect was untrue is because that claim that he had collected these false medical reports at Oriri police station where they had been taken to the accused person flies in the face of the letter dated 13th June 2022 produced by the second accused as defense exhibit 4, in which the investigating team was giving the second accused a notice through his advocates to produce original copies of the same documents. Having totally and thoroughly evaluated the evidence presented by the prosecution in support of his claim that the third accused jointly with the other accused persons or other persons not before the court execute in common with having thoroughly examined the prosecution's case, seeking to prove that the third accused planned in conjunction with the accused persons and in execution of their common intention to cause the death of the second to cause the death of Sharon. And having juxtaposed that evidence or compared that evidence with the evidence adduced by the third accused, I have come to the conclusion that the third accused was not a passive bystander, but was an active participant in the events that resulted in Sharon's death. His conduct of assisting the second accused to invent a false alibi to cover his tracks on the night Sharon was unlawfully killed is incompatible with his innocence. It is also noteworthy that although the third accused testified that he did not report directly to the first accused in the course of his duties, the data records produced by PW40 in respect of the first accused's mobile number, that is 0722469587, shows that in the 2 days between 2nd and 3rd September 2018, the first accused made a total of 5 calls to the third accused. The call data records produced as XB64 show that the first accused made the first 2 calls on 2nd September 2018, and the other 3 calls were made on 3rd September 2018. The third accused call to the first accused was made on the following day, that is on 4th September at 7:31 p.m. The number of these calls per day and on days that were either just before or on the day that the offense was committed, and on the day subsequent to commission of the offense, give a reasonable inference that these calls were made for purposes that were connected to the offense that was committed on the 3rd of September 2018. Or for purposes that were in furtherance of ensuring that there was planning and coordination of the events that led to the commission of the offense on that date. I make that finding based on the timing and the frequency of those calls, and also because the content of those calls were matters that were within the special knowledge of both the first and the third accused persons, and under section 111 subsection 1 of the Evidence Act, the burden of proof shifted to the accused persons to explain the reasons that these calls were made in the manner in which they were made, and in order to rebut the presumption that the calls had been made for an illegal purpose. The first and the third accused failed to to discharge that burden. Having carefully appraised the evidence on record in its entirety, it is clear to me that the evidence demonstrated, it is clear that the evidence adduced by the prosecution in this case demonstrated and left no doubt that the accused persons acted in concert, jointly with others not before the court, pursuant to a common design, each performing a distinct role in furtherance of a criminal enterprise that resulted in the death of the late Sharon. To summarize, the first accused supplied motive, instigation, and funds to finance the criminal enterprise. The second accused facilitated execution, where the third accused ensured logistical support and concealment to avoid detection of the offense. Inherent in these roles were acts of preparation and concealment, denoting knowledge, participation, premeditation, and intention to execute their common intention aimed at executing their common intention that ultimately led to the death of Sharon. These acts constituted malice aforethought as defined in Section 206 of the Penal Code. The fact that the first accused alibi that he was not in Migori County at the time the offense was committed, and the same was vindicated by the evidence that was produced in this case, and that he was in Nairobi from the 2nd of September all through, even from he was in Nairobi from the 2nd of September. It was not therefore physically in Migori when the offense was committed. That's not, meaning that he was not physically present in the place where this offense was committed, does not shield him from criminal culpability, since under the doctrine of common intention, criminal liability does not depend on who physically commits the actus reus, but whether the accused acted in concert with others to execute an unlawful purpose. Applying the legal principles governing the application of circumstantial evidence to the present case, and having in mind the law regarding the definition of principal offenders as stipulated in Section 20 of the Penal Code, I am satisfied that the circumstances presented in this case, taken cumulatively, form a chain so complete that there is no escape from the conclusion that the accused persons, jointly with others not before the court, committed the offense charged. The evidence on record irresistibly points to the fact that the accused persons with malice aforethought unlawfully caused the death of Sharon at the material time. It is therefore my finding that the prosecution has proved its case against the first, the second, and the third accused persons beyond any reasonable doubt. I consequently find each accused person guilty of the offense of murder, contrary to Section 203 of the Penal Code, as charged in Count 1. Each accused is accordingly convicted under Section 322 of the Criminal Procedure Code.
May I request that you guide us into the next phase of this trial?
Okay. So, the councils representing the state I do not know, and I seek to find out from the council on record whether they are ready to take directions on the sentence hearing, and whether the councils representing the state are also ready with the information regarding whether or not the first accused person, the accused persons have any previous convictions or not, so that we are able to give directions on the way forward.
Yes, my lady. Apologies, I was late. I had a meeting I had to attend. In regards to directions, we're ready to take directions on sentencing hearing. We would also like to be given time to get the reports on any previous sentences. So we can start.
Yes, into the courts. We'd also be requesting the courts.
So, start again, Mr. Good.
My lady, I said that as for the Republic, we are ready to take directions on this matter. We do not have the previous convictions reports for the accused persons.
You are very fast.
Oh, sorry, I apologize, my lady.
You're saying you started by saying that you apologize for coming late.
Oh, yes, my lady, I apologize for coming late. I had a meeting which